Can
The
you see the
broadcast is
IACC
now
logo?
starting. All attendees are in listen-only mode.
We are live.
Good afternoon, everyone. This is Naushad, Panjwani here. I'm the Regional President of Indo-American Chamber of Commerce, Western India Council. I welcome you to this third webinar in the series of COVID situation. As we are halfway through in our lockdown in India, and there is a lot that we have learned in the last few days. There is a lot that has come up in terms of questions, what's going to happen, our realization in terms of what needs to be done once the situation is under control. The very first question that comes to mind is what's going to happen on the first day after the lockdown is lifted. As regards today's webinar, we have picked on a subject which is prime on everyone's mind. We are reading in newspapers, pink slips are being issued left, right, and center. Some announcements are being made by various governments on what can be done, what should be done, what cannot be done. In India itself, I have seen various state governments coming out with numerous announcements. Holistically, if we look at it, it's quite confusing. It's quite also a worrying situation. The question in people's mind is, after the lockdown, are we going to see lockouts? Which are the industries that are most affected, which are all human-based, and presently they are under siege? Hospitality, travel, and so many others. Are all industries looking at a negative scenario, or are some industries benefiting from this, or are looking at an upside from this? And we have members across the country, as well as we are in the Indo-American trade corridor. So it is in fitness of things that today we have got two experts who will take us through this scenario on the managing our workforce in the COVID-19 situation. We have Anand Desai and we have Poorvi Chothani, both very, very well accomplished lawyers in their own rights. With this, let me make a couple of suggestions. The administrators of this webinar are also looking at the questions simultaneously, so you are all requested to start posting the questions, not wait till the end. The panelists will take these questions up in their judgment, whichever needs to be picked up and what they can answer and what they are relevant. Secondly, we are going to post the link to the recording of this webinar as soon as the webinar is over. So those who have missed or will join late can have the benefit of that. Also, they can share it with other people if they find this useful. The next webinar in this series is on Thursday, announcements of which you will see very soon. With this, may I request Anand to take over? Anand.
Thank you, Naushad, and thank you, Indo-American, for organizing this. The topics are very relevant currently. And before I jump into the topic directly, I wanted to just give a brief set of dates to demonstrate how quickly this has come upon us and how the reaction time has really been extremely short for governments around the world to decide what to do. So very quickly, 31st December 2019, a pneumonia of unknown cause detected in Wuhan, China, was first reported to the WHO country office in China. India reported one case in January. By 30th of January, which is a month, the outbreak was declared a public health emergency of international concern by WHO. By 11th February, another 11 days later, WHO announced a name for the new coronavirus disease, which is COVID-19. On 11th March 2020, which is another month later, They characterized it as a pandemic around the world. Now, India reacted in different ways because we have, as you know, a central government, we have state governments, we have municipal corporations in metros, each of which has certain powers under certain statutes. Today, we really focused on the employment aspects. So on 19th of March, the Ministry of Corporate Affairs put out an advisory for work from home and relaxed requirements for physical board meetings, and a few other changes were brought about in terms of relaxations. Within days after that, many state governments announced through circulars and advisories what in their state should be done. Certain municipal corporations also took it upon themselves to start exercising their powers under the municipal laws. And very shortly thereafter, 20th March, the central government, Ministry of Labor and Employment, issued an advisory not to terminate employees, particularly casual and contract workers, and not to reduce their wages. Now, this was clearly a situation where potentially there was going to be a lockout. Public transport may be brought to a standstill. Offices were closed out of fear or out of direction, both. And the question became that what happens to these persons who actually need pretty much a daily wage, many of them, and we have a large number of them in this country, apart from employees at various levels. Now, although this was designated as an advisory, it had two specific directions in it. One, that employees are deemed to be on duty, even if on leave or if the place of business is non-operational, which means either they could not attend work or come to work. They were deemed to be employed, which meant the obligation to continue to pay them remained. On 24th March evening, the Indian government announced a lockdown under the Disaster Management Act 2005 and exempted essential services which were listed, food, medicine, etc. That list has been expanded by the governments primarily because there was lack of clarity in many cases, and also as a reaction to what was really required. Now, as we can imagine, in this kind of a short time frame, to actually think things through is not easy. And the charts, which I'm sure all of you have seen, on the rate of growth of this particular infection in people, the number of deaths, countries which are really unable to manage the situation because the medical facilities do not merit that kind of a influx of patients, has really been drastic. Now, a lockdown being announced under the Disaster Management Act of 2005 has various repercussions. This act was brought into place to address situations which were actually considered to be disasters, whether all over India or in parts of India. As you know, in the past, we've had an old Epidemics Act, pre-19th century. We've had various laws which are more local laws, where the municipal corporation can take steps to evacuate areas, to clean areas, to increase hygiene. But this really being a national issue was taken up at the national level. Now, what are the consequences of not adopting such a direction? Because a lot of people are asking questions that, look, it's all very well that the government thinks that this is something that's going to be requiring this reaction. But what happens to me if I cannot function, if I cannot pay when I'm told to pay, if I cannot sack employees? So let's look at the consequences, and then we'll just run through some of the potential options we have. So under that, they have a right to lay down policies, guidelines, direct state governments to follow guidelines, recommend provision of funds for mitigation, and even provide support to other countries. Because as we have seen, almost all countries now have decided to lock down all entry and exit. Because this having originated in a foreign country, and having spread through various countries, it is a step taken which India has locked down as well. If anybody does not follow these directions issued pursuant to this act in India, there are various punishments, including imprisonment, penalty. These could be for obstruction, for making a false claim, in this process for misappropriation of money or materials, for giving false warnings. And there is a whole hierarchy of officers, district magistrate downwards, who are entitled to actually look into both the compliance, taking steps, non-compliance, and taking steps for that as well. We also have a section 188 under the Indian Penal Code, which prescribes punishment for disobedience to an order duly promulgated by a public servant. So clearly, companies or businesses that are not in the exempt list, if they do not follow the directions, they are going to be in some level of potential trouble in terms of prosecution, penalties. Now, how these will be imposed, we have to wait and see, because another very relevant question that's arising is that it's all very well to say, please keep paying people, but please understand my own income has stopped or my business's income has stopped. I have no access to the office. I may not be conversant enough with things like net banking to actually make a payment through net banking. So what do I do? So number one, to the extent each one can, efforts have to be made in order to make this payment and comply with the law. I'm again restricting myself currently to employment issues. If there's merely a giving up and I can do nothing and, we'll see what happens, that may not be the best position to take. Because in the event, down the line, there is a prosecution, there is some action taken. The conduct of the party against whom it's taken is very important and is always taken into account. So, sincere advice, at least take such steps as you can. I understand some people are saying, but I will become insolvent. I appreciate the position and it's a tough one to answer. But like I said, to the extent you can, especially for the casual labor, contract labor, persons who are effectively dependent for their lives and their families' lives on that day's wages, please do your best in whatever way to comply with this requirement. And do not take a position, again, I'm saying to the extent possible, not to the extent convenient, to the extent possible. Please do not take a position that I will not pay or I cannot pay. Now, let me talk a bit about the second scenario, which is also a valid set of questions being asked. Certain businesses are exempt and are permitted to function. Like I said, pharmaceuticals, communications, banks, as we all know, they are permitted to function. Food. But because of this fear, or because of other reasons, apart from fear, but personal reasons, what if employees of these companies say they cannot come or will not come to work? Number one, it's an employer's job to do whatever he can in order to ensure the place of work is as hygienic and safe as possible. There is no public transport effectively today, although I do see some taxis running. So finding a way to get the person safely to the place of work is also important. And while I understand the fear a lot of people have of stepping out, being effectively now an essential service, other implications may follow if the person does not come to work. The situation also is that am I then as an employer required to pay such a person if, although I'm allowed to function, he chooses not to come to work? It's debatable. Probably no, because here there's no reason for him not to come if you are providing transport, if you are providing a safe place of work, etc. Can you ask for a medical certificate if the person says, I'm unwell, therefore I will not come? Yes, you can. Those functions as an employer, to my mind at least, continue unobstructed. There's also a facility you may want to inform employees, and all these are very easily publicly available, where under Employee Provident Fund, there's an amendment that says that they can draw 75% of the amount due to them as a non-refundable advance, which also you may want to advise them to use, if that helps. Now, coming to mitigation, another question often asked is, all right, I understand that daily labor cannot live, or people at the lower stratas cannot live without their daily wage or their weekly wage or even the monthly wage. But what about senior employees? Do I also have to keep paying them the full amount, although they don't report to work or cannot come to work? Now, first of all, the rule laid down effectively is work from home. I understand that certain industries that may not be practical because till you come to a factory, you can't really work. There's no work to do from home. But in several cases, there is. So this is a work from home situation, not a leave situation, number one. Number two, you may have read in the newspapers, some state governments themselves have taken a position that they will defer part payment. They will draw less every month. And I believe this is something an employer can negotiate with senior employees because they should also be interested in the long-term running and conduct of the business and business continuity. And I do not see anything stopping that. Again, I'm saying it's a negotiation. It's not a ground to terminate somebody who's working from home or not working because he can't work from home. So keep that in mind also. I know this is a short seminar, so I do not intend to ramble on at this stage, but happy to answer questions that you may have. Thank you.
Thank you, Anand. I think you have summarized all our concerns so beautifully in the limited time. Once again, I request all those who have logged in. I can see 125 people have logged in as of now. Please keep posting your questions, and the two panelists will address them at the end of their session. With that, I invite Poorvi to start her part of the session. Poorvi?
Yes, I'm here. Can you hear me?
Yes, we can hear you.
Yeah.
Go ahead.
Good afternoon, everyone, and thank you, Naushad, Jugal, and the team at IACC for organizing this. It is a very timely topic that you all have chosen because of what is happening in the United States, especially with our IT companies and other companies that have got Indian nationals working in the United States. So to set a little bit of background, America has reported 3.3 lakh cases, more than 3.3 lakh cases, and more than 9,500 deaths, with the worst areas affected being California as a state, Seattle as a city, and New York City. We are about 2 to 4 weeks behind the coronavirus cycle in India, and I hope our numbers do not come close to them. I don't want to be like America. So I hope this is one time we are not like them. The biggest concern with everybody is how to manage your expenses and how to manage your H-1B worker staff at in the United States, many of whom are posted at client sites. So H-1B workers are generally taken, I'll talk briefly about L1s later on, but most of the issues are governing the H-1B workers. So H-1B workers are generally sponsored by American companies, which are wholly owned subsidiaries or affiliates of Indian companies for our topic today. And they can be posted at their own offices, or they can be posted at the client office, which we call the end client office or end client work site. Many of the end clients have terminated contracts or have suspended contracts with the IT companies. As such, these people are unable to render services. Many of these have been suspended because they need to be physically present at the end client site because the technology is such that they have to be on their premises, or because the requirement has been suspended for now. For example, in the aviation industry, none of the airline companies really want to do any upgrades at the moment. They're just all in a wait and watch mode. The other problem is that some of them cannot continue their projects because of the work from home advisory that the states have given. It's important to know that all the states have not mandated work from home. There are about 8 states who are still not mandating it. But the rest of the states, and the states which are really clusters for IT companies, have mandated it. And then the end client cannot allow the H-1B worker to work on their project due to security reasons. They're not allowed to give them access remotely, or they're not allowed to give them data that they can process on their workstations because they had not planned for such a remote working scenario. So these are two of the main reasons why work from home is not viable for many of these H-1B workers. Now, what happens then is that these individuals, when they are working from home, there's a work site change. When you file an H-1B petition, you've got to make certain attestations and promises to the Department of Labor by filing something called a labor condition application, or an LCA. And one of the things that you stipulate in that is the work site and other terms of engagement, salary, work site, job duty, etc. If there is a change in work site, there is a need sometimes to do another LCA, to file another LCA, and or file a petition with the USCIS. Now, the question with most of the employers is, should we do something now? Do we need to do something immediately? The answer to that is that no, let them work from home. And even if they don't have work, you'll have to continue to pay them their salary. And the Department of Labor's regulations state that for 30 working days, if there is a change of work site, you have no obligation to file a new LCA or a new amendment petition with the USCIS. So for 30 working days, which in effect is about 6 weeks, you are fine. You don't have to do anything. All you have to do is the original underlying, at the moment, you don't even need to do that. So, okay, for 6 weeks, you're fine. Before the end of 6 weeks, you have to reassess your position. And then you've got to post the LCA at the home work site. One of the obligations on the LCA is that you alert all affected employees, including American workers, of the LCA work of the H-1B, the foreign national who's going to work in a particular position. It's called LCA notice or posting notice obligations. Now, this notice kicks in at the end of the 30-day working period, and you should post the LCA at the new worksite, which is the home of the H-1B worker. It is a bit funny because how does the affected worker come to know about it, but yet you've got to do it. If you're going to do that, you also need to post your LCA online on your internet and send an email or communicate to the affected workers in some other manner. There are many options on how you can do this, but it's beyond the scope of today's presentation. There is another exception to these LCA obligations, and that is if the person is going to be away from the main work site for up to 60 working days, provided the H-1B worker continues to maintain a permanent place of work at the primary work location. What does this mean? If the employee has a dedicated workstation, a computer that is assigned to him, he has got electronic data card to allow him entry and exit into that office, proof to show that that is his primary work, then this LCA posting notice is suspended for 60 working days. However, even when you do that and you feel that you can't pay their salaries, what should you do? If you cannot pay their salaries, the best thing to do is for you to terminate their employment. Now, should you terminate their employment immediately, or do you have a window here? The US government has announced a very, very powerful and useful scheme for small businesses. And small businesses are defined for this scheme as the companies with less than 500 workers. And it's called the Paycheck Protection Program, where the Small Business Association under the US government is going to help companies protect the jobs of these 500 or less employees that they have. And they're going to give them 2.5 times the amount that they spend in payroll in a month. At the end of an 8-week period, I mean, this is to help them pay the salaries, social security benefits, insurance, and retirement benefits for up to 2 months or 8 weeks. At the end of 8 weeks, if you can prove to the small business association, or the designated agent, which they're still figuring it out, is going to be a bank and they're still figuring out the logistics. If you can prove that you've not laid off any employee or reduced any employee's work hours, then your loan is going to be forgiven, which is a huge deal to protect workers. Now, the question is, can wholly owned subsidiaries of Indian companies avail of that? Yes. Any American company can avail of it. It has to be a company that is incorporated in America. So yes, they can avail of this. The larger companies above 500 employees also have some benefits, but they are not as generous as this. They are getting preferential loans. They're getting loan interest deferment and other measures to help them tide over these tough times. Now, what happens when these individuals, they don't have work to do? What do you do about them? It's called non-productive time. Like I said, you've got to pay them their salary. And you really have a 30 to 60-day window in which you decide what to do. However, by then, if you decide that you can't manage having them over there, you don't have the option of sending them on furlough. I am sort of weaving in the second last point over here. You don't have the option of sending them on furlough, though technically we could argue that if the US workers are put on furlough, then even the H-1B workers should be allowed to be put on furlough. Technically, that is correct because you've got to treat them as the same as you treat American workers. But the problem is this, that the USCIS is going to turn around and say, if you do not have work for your H-1B workers, why do you need them in America? Send them back. Because one of the obligations of an employer is to terminate their employment when there's no work and give them an air ticket back home. They have to do that. So if you can't manage the payroll, it's time to inform the USCIS that you're terminating this person's employment and give them a ticket to go home. Now, how can they come home? Flights are suspended. They're not allowed to travel. So what happens is they have a 60-day grace period after termination to stay in America to either find a new job or wind up their affairs and leave the country. Within these 60 days, if they find another job, the new company can file an H-1B petition for them and they can take it up. If all goes well and things go back to normal, even the existing employer who's technically terminating him can re-employ this H-1B worker and file a new H-1B petition for him. So basically what they've done, what you can do is really put them in termination status, but refile for them again. There are technical issues with that. It's not a seamless process, but that is one strategy you could consider. What about reduction of salaries and reduction of work hours? Now, reduction of salaries, if you're going to do reduction of salaries across the board of all your employees, you can consider reducing the salaries of H-1B workers. But there are 2-3 things you've got to keep in mind. In the LCA, you have stipulated what you're going to pay them. So you've got to be sure that the reduced salary does not violate your commitment in the LCA. You've also got to make sure that they're informed and they give you consent about the reduced salary. To do that, you don't need written consent, but it is better for you to have written consent and to include it in the employer's HR file. One of the other obligations of the LCA is to maintain something called a public access file. So it's better to document the salary reduction and a copy of a new employment contract evidencing the salary reduction in the public access file. Now you come and you've got to be sure, like I said, that you do not fall between what you're supposed to pay them. That's the required salary. The next thing is reduction of work hours. You can reduce their work hours. However, you've got to keep in mind your obligations of the LCA even there. Generally, LCAs are filed for 40-hour weeks, but if you're reducing them to 30 hours, you can reduce their salary proportionately. But again, you've got to be careful of your salary obligations. One way employers are considering addressing this is by putting them on lower salaries or lower work hours and promising them in writing that at the end of the year, they will get a bonus. This is allowed and this would help meet your salary obligations, provided the bonus is not contingent on any future event. It has to be a definite bonus. It's just going to be paid at a later date. Can you give them stock options instead of salary? No, you cannot. Stock options are not counted. So these are the main things that you all have to consider. The best thing is the Paycheck Protection Program. It gives you a 2-month window to get your act in order. However, unfortunately, it does not apply to the larger companies. I'm ready for questions now, Jugal and Naushad, if you wish. I mean, there's lots more we can say, but I think it's time for questions.
Thank you, Poorvi. We have enough time for questions. Jugal, would you like to pick out some questions from what we've received?
Sure. I've got the first question for Mr. Desai. Mr. Desai, the question is, if in these times an employee is terminated using an excuse of long-term observance of poor behavior, does the employee have any recourse?
The employee will have recourse under this particular set of advisories and notifications, because while you may have built grounds to terminate, you have not actually effected the process from what I understand from the questions. So I would advise you to wait and not do it now.
Thank you. One more question for you, Mr. Desai. Does the government advisory for not laying off employees have any teeth when it comes to the private sector?
It does. Like I said, the laws being enforced currently or being used currently at the central level are the disaster management laws, which gives the right to the government to take very, very wide actions in order to keep the disaster under control and try and ensure it's properly addressed.
Thank you. We have one more question. The person says we are into international arbitration and mediation. There is a total lockout globally. Any suggestions on how they can take this forward?
I'm not sure what that question means, because I do know that some arbitrations are going on through video conference. There are some courts functioning in India also, although only for very urgent matters. So it's a very general question, but if you can find a way to continue the proceedings through video conference and both parties agree, the arbitrator agrees, the mechanism is there to do it, please go ahead and do it. There are matters going on, I can tell you.
Okay, there's one question which seems fit for both the panelists to address. It says, would deferment of salary tantamount to non-compliance? Is the advisory to pay recommendatory in nature, or is it mandatory?
Anand, go first.
So deferment would be seen as non-payment, because the obligation to pay is to pay now. And sorry, the second part was what?
Is the advisory to pay recommendatory in nature, or is it mandatory?
Well, number one, it depends which state you're in, because there's a national advisory and there are state notifications and advisories. So I don't know which state you're talking about, but I would advise you to please check before taking a position on this. In principle, but I would say that the government will look at this as directory and not as recommendatory if they do decide to take action. And ultimately, you run the risk anyway of defending an action at a point of time in the future.
Jugal, you have any questions on that side?
Yes, I'll just read out a couple of them. We have one that,
Yeah, sure.
Can we do a payroll cut or ask employees to take unpaid leave during COVID-19 or after the lockdown time? And what would be the procedure to implement this?
It would be nice to ask the audience to specify which country they want the answer for.
I mean, you can both look at it simultaneously. If it applies to US also, I think that's a well worth answering.
Purvi, go ahead. Yeah, Purvi, go ahead on this one.
Yeah, so you can, like I said, you can negotiate a pay cut with the individuals, but that pay cut has to be uniform across all employees. It cannot only be for the H1B employees. And you have to have the employee's consent, and you've got to make sure it does not fall below your LCA obligations. Go ahead,
So
Anand.
for India as well, like I said, for employees above a certain level, the possibility, what is called contract-driven employment, like senior management, managerial staff, etc. Nothing stops you negotiating with them and talking to them to see how best you can continue your business. But the lowest end, it's not really practical to do that.
Thank you.
Well,
We have one more question. Poorvi, perhaps you can take this up. We are a manufacturer, exporter of leather goods, and we would like to have a directive respect to our field as well as marketing our products in the US.
I think that question is a little beyond the scope of this seminar, but I'll just quickly answer it. You can always sell your goods in America on a B1 visa, which is a business visa. So it's not a work visa, it's just a temporary visitor's visa for business. But if you want to expand your market further, you've got to establish a company, and in that company you have to have US workers, and then you can also sponsor an Indian worker to go and help you establish the business there. That's the short answer.
Okay, so if you have done, are there any questions, Jugal?
We have a few more questions, Naushad.
Yeah, so go ahead.
One more for Poorvi, in fact. Can you please throw some light on the scenario like H-1B or L-1 holders' inability to travel back to India post the retrenchment owing to the travel embargo?
Right. That's a very good question, and I'm glad you brought it up. What happens is that when you are, or both the H-1B worker and the L-1 worker have a 60-day grace period at the end of their employment. An L-1 worker cannot find a new job in that period because he is tied to the parent company or the foreign company, that would be the Indian company in our case. However, they still have that window. When they are close to the 60-day mark, what they should do is file a petition or file an application with the USCIS to change their visa status from an H or an L to a business visa or a tourist visa as appropriate. As long as this application is filed before the expiry of the 60 days, it is considered a timely filing, and any time that is clocked within the United States after it is timely filed is not considered to be unlawful presence. Why is this important? It is important because the moment you have unlawful presence, you are actually tolling. Time is tolling, and if you hit the 6-month mark, which we really don't know could happen, then you're going to be barred from entering America for 3 years. So the best way to protect yourself from that is to file a timely change of status application to a B visa.
Thank you, Poorvi, for your comments. One more question, perhaps Poorvi and Mr. Desai, you can both share your perspective. Is there any legal recourse to employees for mental stress arising from getting laid off or from being terminated, and any modifications to the relevant laws to address the current times?
Anand, go first, please.
Oh, so India, like I said, the current scenario by and large in almost every state is do not lay off somebody. They would have a recourse for being laid off, not necessarily the mental harassment part or the stress part.
So for America, the situation is more, more risky. Over here, the problem is this, that even if you negotiate with your employees to take an hour cut or a pay cut, they may agree, you may even have it in writing, but they still have the right to complain to the Department of Labor under their whistleblower provisions and say that these people did it only to avoid their LCA obligations. So employers in America are very, very wary about giving these employees an opportunity to hold on to their job, because they're very eager to hold on to their positions in America, because even though everything seems hunky-dory when they're negotiating the pay cut and the hour cut, there is always the risk that the company could get into trouble. So, and the mental health and all those type of things, yes, they could sue them for that, but then their chances would not be very, very high, because America follows the employment at will provision. So yes, you're allowed to throw out people whenever you want. It's just that with the H-1B workers, you've got obligations.
Thank you. One more question, Mr. Desai, perhaps you can take this up. What is the support given from the government, from the industrialists and the public for the aviation industry, as this is an essential for the way ahead? So any thoughts on that one?
I don't know of a specific announcement yet for aviation. And I think it could be at a slightly later point of time, because currently all international flights, from my understanding, are stopped, and even domestic ones are hardly operating. So it's going to have a huge impact undoubtedly on aviation, on hospitality, there's hotels, tourism, etc., which may continue. But I don't know of a specific relief given to them yet, independently of the other general ones on banking and deferment of certain tax filings, etc.
Okay, another one on similar lines, Mr. Anand. It's if you are in essential services and people do not come to work, how do you compensate and differentiate between people who come to work and the ones that do not?
So, like I said earlier, I think essential services, there is an obligation to come to work, because there's no restriction, for one. Plus, at a time like this, the expectation is you will come and you will work. Now, there are obviously essential services which are designated, like firefighting, the fire brigade and the police and all that. And there's this private sector like pharma, food, which are permitted today. So if an employee does not come to work to a private enterprise at this time, I would treat him like any other employee in normal times, because there's no embargo against his coming to work.
Thank you. A few more questions, please. One of the attendees says that whilst we have spoken about compliance, mostly in the favor of employees, are there any thoughts that you all have to share with regards to employers from a compliance point of view?
I suspect this is more in America than India.
Yeah, all these compliance obligations are on the employer. They are vis-a-vis the employee. And today's seminar, we are focusing on these, on the workforce in America, which affects the Indo-US corridor, and that's why we picked the H and L categories. So you do have that obligation to fulfill your LC obligations. For the L1 workers, there is no such obligation. L1 workers can be terminated immediately, salaries can be renegotiated, salaries can be suspended. You have a lot of leeway with your L1 workers, which is the senior level managers and executives, and also the specialized knowledge workers. However, with the H-1B program, you don't have that flexibility.
Thank you. One more question. Typically, incentive payouts and salary revisions fall in the April and the May month. Can an organization decide to defer one or both in the larger interest of maintaining cash flows and timely salary credits?
In India, I believe they can, because if you've not yet announced it, it's not an entitlement of the employee or the worker. So unless you have a commitment in writing or commitment otherwise recorded of an increment, I believe you can defer it.
Yeah, in the US, you can definitely, provided you've not made any commitment to the employees, which is usually not the case over there. Again, it would depend on the states, because the states have very specific employment laws, but broadly speaking, there wouldn't be an issue if you deferred it.
Thank you. We have one more question. Poorvi, I think perhaps this would you could pick this up. We are manufacturing and exports of electrical fittings into the US, classified as essential services in the US. If the lockdown in India does continue for long, number one, how long do we continue paying our factory workers since all our factories are shut? And number two, if we do open our factories with special permission, do we continue to pay our workers, and for how long if they refuse to come to our factory out of fear?
Jugal, I understand that the factories are in India. He's supplying to companies in America which are essential services.
That's
so
what
the
I
factories
understand.
seem Yeah, so the factories seem to be in India. So Anand, back to you.
Sorry, the moment you said Poorvi, I sort of switched off. Can you repeat the question?
Sorry about that.
My apologies. Can you repeat the question?
Sure. It's a company that's manufacturing and exporting electrical fittings into the US. It's classified as essential services in the US. If the lockdown in India continues for long, how long do they continue to pay their factory workers since their factories are closed? And if they do get a chance to open their factories with special permission, do they continue to pay their workers, and for how long if the workers refuse to come to the factory out of fear?
So if it's not an essential service in India, and again, it depends on the state, like I said earlier, then your problem is going to be not the US importer so much in this discussion. You may have other problems with him in terms of your contractual obligations. But as far as the employees are concerned, they'll be treated no differently to what we discussed earlier. So the ones at the lower end of the scale, whether it's the casual worker, the contract labor, etc., certainly you should not make any change in their employment terms during this period. As far as senior people are concerned, as I said earlier, you have an ability to negotiate. If you can come to some understanding with them, good for you. And I understand the difficulties of a factory being closed. And I believe there are some industry association initiatives taken with the government to say that, look, you're telling us to keep on making payment to people, which we would like to do. But the reality is that we may not have the ability to generate the money, or we may not have the reserves to delve into. But that's not yet happened. So until there's some clarity there, what we discussed earlier pretty much will apply to your situation.
Thank you. Puri, we have one question for you. It says, if we do not file the case of 2020 H1B cap select, is there any impact?
Okay. So just sort of to give a little bit of background over here, America accepts H1B petitions every year from April 1st for an employment start date of October 1st of that same year. That is after 6 months. This is the first time that they've conducted an online lottery. And every year it's a lottery because they get more than the visa numbers available. They have a total of 85,000 visa numbers. Last year they received 190,000 odd applications. And this year they have received 275,000 odd applications. In view of this, an online lottery was conducted, and on March 31st, up till March 31st, the visa numbers were announced that they've reached their total, and all the selected cases are ready now to file. I mean, they are eligible to be filed. Now, the problem is this, that between the selection process and between the time in December or November when they were making business projections and now, the world has changed. So companies are very worried about what's going to happen, because the government had announced when they introduced the online system that if they do not use all the visas that are selected, so let's say a company got 100 cases selected and they decide not to file all the 100 cases, they could be penalized and barred from future H1B sponsorship, among other things. So there is a bit of leeway over there that if a candidate left the job or if a candidate doesn't want to join, things like that. So, they've not given you the number. They've not said 30% of them you don't need to file. But I'm saying if you didn't file 3 of those cases or something, you're not going to have, you're not going to be penalized. But if you're not going to file 40 or 50, as per current law, you do face the risk of being penalized and blackballed from future sponsorship. However, the government, they haven't announced anything, but the government is likely to announce something, and the American Immigration Lawyers Association is working hard to get things moving with them. In fact, on Friday, they have also filed a suit against the US government because of their lack of relief for immigration. So at the moment, be prepared to file all your selected petitions. Watch this space, because if they come out with an announcement, you could get away with not filing. You may well argue that this COVID-19 situation is like a force majeure, it's beyond you, it's a situation beyond your control. You could argue that, but As per current regulations, you may not succeed. Of course, you could still take the US government to court. But, that would probably be like killing your own business. Tread carefully is my advice.
Thank you. One more question. This is from Mr. Desai. Mr. Desai, is there a possibility of applying force majeure clause even in its absence in the written contract on incomplete projects, loss of livelihood, disruption of supply, lease rentals, etc.?
Okay, this is outside the topic for today, but just a quick answer. A force majeure clause is a force majeure clause. There's no force majeure concept outside of a clause. So if your contract does not have a force majeure clause, you cannot invoke force majeure.
Thank you. One more question. I think, Poorvi, this would be for you. Is the social security part of the wages included in the calculations of 2.5 times of the salary?
Yes, it is. So it is social security dues, the salary, the insurance premiums that you pay for your employees, and the retirement benefit contributions. The government has, the rationale behind this is that they don't want a whole lot of people falling out of insurance because America does not have public health care. So they don't want to have a situation of thousands of employees without a job, which would result in no insurance. So one of the reasons why they're giving you this is to protect that. But yes, social security contributions are included. There are a couple of caveats over there. The salary the salary they're going to cover is up to $100,000. So if you have employees who are receiving $120,000, they'll only cover you up to 100, and the total cap on the loan is $10 million. So there are a few caveats there, but still it's a huge amount for small businesses and a huge saving, to keep the business going for 2 months.
Thank you, Poorvi. One more question. This is both for India and the US. If we do voluntary pay cuts for senior managers, directors, and above, is that okay? And what would be the procedure for that?
So for India, I would say it's not a pay cut, it's a renegotiation of a contractual obligation for a short period or a long period, depending on what you negotiate. Because senior employees, like I said, managerial, etc., normally given an employment contract or employment letter that sets up the negotiated terms of the understanding of what the services are and what you pay them. So that is open to you to negotiate, but if the person stands firm and says, no, I want every single rupee, then with the current situation as it is, you would be obliged to pay them that every single rupee. Again, I'm saying in most states, so please check which state you're asking about, or check what the rule or notification or advisory is in that state.
So for America, again, the state law will apply, but like I said, most of the states have employment at will. So if your employee is not on an H-1B visa, you can do the pay cut, or you can renegotiate their salaries. And the best thing to do is document it. I mean, in most states, you may not need to document it, but it is better to document it and get written consent for the pay difference. For the H-1B workers, I've already covered your obligations. And so even if your senior manager is on H-1B, even if your CEO is on an H-1B over there, he has to be protected. But your chief technology officer who's really drawing 1/3 the salary of the CEO, he's a local American or he's on an L1 visa, you can renegotiate your salary with him or even give him a pay cut or just throw him out.
Thank you. One more question. In case there are interns who are due for coming on permanent payroll, can the employer decide not to continue with their services at this point in time?
US or India?
The person's not mentioned it. Would there be different perspectives to each of them?
Yeah, they would be.
US, I don't know. Yeah. Poorvi, why don't you answer, Poorvi?
Okay. So in America, there are two types of interns. One is the intern that is a local worker, that is either an American citizen or a green card holder or somebody with special status who's authorized to work over there. Then you've got the foreign students who are given 1 year of internship called optional practical training. at the end of a 1-year program that they've graduated from. So at the end of a bachelor's degree program, you get 12 months OPT, and at the end of a master's degree program, you get another 12 months OPT. So at each level of education, you get 12 months of OPT. Now, and these people are eligible to be considered for H-1B. So if you've given an OPT worker a job offer and he's selected in the H-1B petition, that's when your question will be, do I have an obligation to employ him or not? Under the immigration laws, you don't have to employ him, but if you have a selected H-1B petition number, again, you've got to be careful about the penalties for not filing. With the other interns in America, it's again employment at will, so you're most likely not going to have any problem with not onboarding them if you don't want to. You might have notice obligations, but otherwise no problem. But with your OPT converting to H-1B, you've got to be careful.
Thank you. Mr. Desai, any thoughts from your side on this, or can I move to the next question?
So in India, an intern technically is not an employee. If what is commonly called an intern is what you're referring to. So unless there's an employment letter given that takes effect on a particular date, I don't believe the person would be treated as an employee.
Okay, thank you.
Anand, Poorvi, we've got you got about 5 minutes left for this session. Jugal, how many questions more in the pipeline?
We have a few more questions. I think I'll probably just take a couple of them and then hand it over to you all for closing remarks.
I don't know whether Anand, Poorvi, would you like to extend this session, or are you all busy, or what? Accordingly, we'll.
I can do 10-15 more minutes.
Yeah, I can as well.
Okay, so then let's extend by 5 minutes. Take a couple of questions fast, Jugal.
Sure. All right, so this one is both from an India and a US perspective. It says, instead of wages, can we reduce the employee's leave basket by, say, perhaps 5 days so that it has no impact on the monthly wage? But does the organization stand to gain from a reduced leave basket?
So I don't know whether that's relevant in India at this point of time, because all they're saying is that if he does not remain present, do not treat it as leave. But if he's, so I'm not very clear how the question will translate into that particular provision.
So in America, they've actually given clarity on this, that if an employee is asking for leave because either he is sick or he needs to take care of a sick person, provided they give evidence of this, then theirs would be considered as paid sick leave or paid leave of absence, personal days. It will be counted towards that. But other than that, if they just choose to say that I'm not coming to work, that could be a trigger for unemployment or to be terminated. But otherwise, they've got to provide evidence of why they're not coming. And again, any leave that they take, personal days for which they generally don't have to give explanation, as long as it is part of either their employment contract or a HR policy that the employees have been made aware of, then the company will have to abide by that. They'll have to fulfill those obligations and give them that much of paid leave, personal leave.
Thank you for your comments, Poorvi and Mr. Desai. One more question. Poorvi, I think this would be for you. Being appraisal time, can we release any employee in the US? By employee, the person means either an H-1 holder or a US citizen on grounds of performance under the current circumstance.
So again, you'll have to be careful about your state employment laws. But let's say if you're talking on the pure federal immigration law, with your H-1B workers or your L-1 workers, you don't really have to give them reason for why you're terminating the employment. And that even applies to US workers. You don't have to give them a reason. So if you decide at your appraisal time that you don't want this individual, you can terminate him, but be sure to inform the USCIS and be sure if possible to withdraw your LCA, because that then terminates your employment obligations. Because otherwise, let's say you say, okay, I am terminating this individual, but you don't inform the USCIS, you don't give him a ticket to come home, then your salary obligations continue. And he could complain to the Department of Labor and you will be forced to pay back wages, penalties, and you will face other strictures. So if you decide to terminate any person there on a work visa, do it completely, finally, and clearly.
Thank you, Poorvi. Mr. Desai, there's one question for you. It's a long question. The Industrial Disputes Act expressly allows organizations to lay off, which means to temporarily suspend workmen during a natural calamity with 50% wages up to 45 days. The model standing order allows organizations to ask employees to go on a paid leave in case they are unable to employ them due to an epidemic. Will the government notifications override statutory provisions?
In this case, they will, because the National Disaster Management Act overrides all other laws. So anything done under that act will override the Industrial Disputes Act. It's a good question, because initially I know the advisory came out as a pure advisory before the lockdown under the act. These questions were being asked by several people to say that how can an advisory override a statute? The issue is but two things. One is that given the time we are in and the sensitivity of what's going on, I think even on a humane basis, the way we were looking at it as a law firm was, the advice was, please do not become technical at this time because this is an evolving situation. And in all likelihood, the government will take recourse to the Disaster Act. And if that happens, anyway, it overrides all other acts. That's a good question.
Thank you. Poorvi, one question, I think this is in continuation of the previous question, which says, is the benefits on top of the wages calculation of 100,000 or is it part of the 100,000?
I don't have the breakup of that, but my understanding it is all inclusive. But I don't have the breakup of that. I'm sorry at the moment.
No problem. Thank you, Poorvi. I think I'll take one last question. What if our tenant sends us an email notification mentioning he does not want to pay commercial rent indefinitely till offices open up, even though there is no force majeure clause in the contract? What should we do as a landlord in India, and should we allow those X number of months of deferment on the rent payment?
Again, it's not an employment question, but
it's a real estate question, Anand. It's a real estate
question.
I know.
Yeah, so maybe I can butt in.
Or not? Does he want to keep the tenant or not?
Yeah, so it's basically a question of demand, supply, and economics in that area.
Yeah.
If the contract does not mention a force majeure clause, there's not much you can do about it. But if there's enough vacancy in that area and the likelihood of the tenant moving out, then you'd better accept those or negotiate these terms. But if you feel that your location, your building has enough demand and the chances of the tenant moving out is less, or if he moves out, then you replacing immediately with somebody else is very high, probably with a better rent, then probably can stick to your guns.
Right, I think.
So, Jugal, I think, yeah,
yes.
Sorry.
Yeah,
Jugal,
we can wrap it up
I think, yeah, so thank you, Jugal. So nicely you picked out. So there are numerous questions, and it was a tough task for Jugal to pick out from all those questions and see that there's enough variety for both the panelists. I thank both the panelists for their view. They have gone out of their scope and even tried to cover the moral angle to it. The parting shot I would like to make on this is that ultimately, if business does not survive, no jobs will survive. So all these are measures in the short run. All these are measures to avoid any panic at this moment. But as things roll out, pan out in times to come, strict commerce business sense has to survive, because if letting go 10% of employees is going to save 90% employees chance of getting employment or remaining employed, I think that's a sacrifice we'll have to make in the long run. Because if there are no profits and if there's no commercial viability, the business may fold up, which it could have in if flexibility was granted, it could have survived. So I think with these words, I'd like to say that thank you both of you all for this excellent disposition. The questions, I thank all of these. I saw at the end of it, there were about 127 people who finally logged in, which is fantastic. And just a little note I have received on the next session, which is there on Thursday. The speaker is Mr. P. Harish. He's the Additional Secretary, Economic Relationships, Ministry of External Affairs, Government of India. Details have been sent out to everybody for the login. This is supported by Tech Mahindra, I guess, so you'll have a different login ID and things like that. So please look forward to that. And thank you, everyone. With this, we end the session. Thank you so much.
Thank you.
Thank you.